of advocacy or law changes, but there are a couple things that I do want to flag because I think they're really important for context. So, first of all, in 1995, the then Governor Hunt formed a Blue Ribbon Commission to study agricultural waste. And out of that grew this statutory language. And I'm not going to read it all to you. What I want to flag here is that there were 5 specific harms or problems with this lagoon and spray field system that the legislature said, if you want to build a new hog operation, then you have got to use technology that addresses this. And at the time, they also said if you want to alter your existing operation or expand your existing operation, then you have to install technology that addresses these specific 5 problems. Now, I mean, those of y'all who have been in North Carolina over the past few years, this is not news to you, but I wanted to just flag the contrast, right? 1996, problems are identified, statute is enacted that says you've got to do better on waste management. Fast forward literally decades, and we are still looking at the same problems. In just the last 6 years, we've been reminded about how serious this problem is. So we were talking just a little bit before I started about Hurricanes Matthew and Florence and how hurricanes are a reminder of the vulnerability of this system and surrounding communities. Also, I mentioned this public health research. The other thing I wanted to flag is, and you may have heard a little bit about nuisance cases. So there were about 500 North Carolinians, predominantly African Americans, who sued under state law, under state nuisance law. And without getting way into the weeds, nuisance law says that you can't unreasonably interfere with the use and enjoyment of your neighbor's property. And these neighbors all sued and said the waste management practices of this industry are unreasonably interfering with our property rights. And what I want you to know is that they presented their best evidence, and they did so in our sort of adversarial legal system. So the industry lawyers got to argue as best as they could and poke as many holes in that evidence and those testimony in those cases as they could. But time and time again, when a jury looked at the evidence, they found in favor of the plaintiffs. And they did so when the industry got to pick its best case, because the way that the court actually handled that, instead of actually going through every single trial, what he said was, all right, plaintiffs, you pick your best case, we'll litigate that one. Plaintiffs won. Then they said to the industry, you pick your best case. Plaintiffs won again. They went back and forth 5 different times. Every single time, the jury's found in favor of the plaintiffs. And that first case, when it was appealed up to the federal appeals court, the liability was affirmed. And then the industry settled those lawsuits. What is not on this slide, but is important to know, and we were talking a little bit about this sort of significant legislative clout and power of this industry. As those plaintiffs were succeeding in their litigation, the General Assembly was literally coming behind them and changing the law. So when they survived a motion to dismiss, the legislature said, let's make it less attractive to the private bar to represent similarly situated North Carolinians. And what they did is they significantly reduced the remedies for a successful nuisance suit. Well, the litigants kept plugging away, and they kept winning. And so the next year, the legislature came back and basically made it all but impossible to bring a lawsuit of this nature. And so similarly situated North Carolinians to those 500 successful plaintiffs are now unable to get to the courthouse, even though they have the exact same legal theory and lived experience. And that's because the law changed. Now,